So, good afternoon, everyone. We are starting another very interesting and promising session about colonialities or dark aspect of colonialism. We have we should have three distinguished speakers. One is Anthony Diala, that you all know from the University of the Western Cape. The second one will be Mary Muscat from the University of Malta. And the third one, hoping that he will join us, is David Zamit, also from University of Malta. We are in front of three interesting exposures. The first one will be, as I said, from Anthony, who is going to talk about coloniality and the future of laws in sub-Saharan Africa, an extremely interesting topic. I know that Anthony is researching on this subject. He is already some time that he's researching on this subject. So I give him immediately the floor. Anthony, please, you have the floor.
Thank you very much. So then I'll start sharing my screen.
We saw it, but it disappeared.
So I'll try again, and hopefully it will work this time. Can you see the screen now?
Yes.
Okay. So thank you very much. So let me start with this slideshow. My presentation, the topic right here, coloniality and the future of laws in sub-Saharan Africa. So there's a context behind this, and the context is this, that several years after many African states gained their independence, they are still struggling with what I call a crisis of legal identity. And so this crisis results from the legacy of colonialism. That's the rules and the values that were imposed by Western Europeans on African countries. One key aspect of this legacy is the coexistence of indigenous African laws with what we know as state laws. Now, these state laws, as I shall explain later in fuller detail, comprise of the remnants and the survivors or adaptations of the European legal systems that were imposed on African states. The key thing, again, is that while indigenous African norms emerged in agricultural settings, the state laws and their adaptations emerged in relatively industrial settings. So considering this dissonance in their respective origins, it's not surprising that conflicts often occur between change agents and traditionalists. And these conflicts usually occur over the property rights of a certain segment of the population, usually the women, the younger male children, and the girls. Another key thing to note is that this conflict occurs mostly in the context of coloniality. By coloniality, I mean the persistent patterns of power and philosophy left behind by colonialism. Now, the legal systems that were left in Africa after colonialism, they are characterized by legal positivism. Some of us may be familiar with legal positivism, others are not, but it generally means the perception that law consists of observable rules issued by a sovereign, and that these rules are enforceable with sanctions, and that we should not impute morality or values into the rules. So it's a rule-centric way of looking at the law. And that was one of the key legacies of colonialism in African nations. So colonialism bred a tendency for uniform rules. That's not the only thing it did. It also influenced the codification of customs. So in many places, colonial officials tried to reduce customs into writing through restatements and through plain self-statements by getting Africans to give their impression of their laws. And then these were put down in writing. So it encouraged colonial judges and those who came after them to sacrifice indigenous values on the altar of rules. And by so doing, they created a sort of dissonance between customs and the official perceptions of these customs. A key output or key consequence of this dissonance is that some scholars started dividing customs, African customs, into official and living versions. That's the origin of the concept of living customary law. But I have a problem with this categorization of African laws or African customary laws. And my problem with it is that the definitions do not tally with the empirical reality. So living customary law is defined as the actual practices of people which adapt to socioeconomic changes. And then they define official customary law as the codifications of customs, as the precedents that flow from judgments of the courts, and the customs generally that are recognized by the state, especially the courts. But there's one key problem with these definitions, and that key problem lies in this fact that courts do not apply customary law. Rather, what they do is to interpret it. We know that the nature of adjudication in many African societies is adversarial in nature, especially in South Africa. So by being adversarial, it means that the party that manages to convince the court as to the validity or reasonableness of its case usually wins. So the result is that judges eventually adopt a version of customs that is successfully pleaded by the litigants. So the accusations by scholars that official customary laws are distorted can be explained on the ground that those so-called distortions of customs involved Africans who collaborated with Europeans or who presented versions of customs different from the reality to the Europeans. Even the African elders, especially the works of Martin Chanok has shown that many African elders collaborated in the distortion of African customs. Those who misrepresented their customs to colonial judges were reacting to the radical changes that were introduced in their lives by colonial rule. Now, these changes range from religion to new systems of education, to fashion, to food, to new systems of work. So it's quite natural to expect people who are encountering a strange, different culture to behave in ways that will secure their own interests. I've even had some sort of jokes that in many African societies that the men hid their wives from the Europeans to ensure that they preserve them, meaning that some early colonial officials did not have much contact with African women and assumed that women had no roles in public life. So what I'm trying to explain with the radical changes of colonialism is that they breed this concept of coloniality, and that colonialism is the sort of flagship of globalization. So the changes that are occurring in the lives of Africans today started way, way back in the past. Since we are living in an era of globalization in which actions in social fields cut across those fields into other social fields, the implication is that the judges are interacting in the same normative community with litigants, meaning that judgments also reflect the so-called living customary law. That is the actual practices of people. And I have traced this influence of globalization not just to the slave trade and colonialism, but even beyond. It's not something that I can present within the scope, the limited scope of this, but the influence of globalization is felt most especially today in movements such as feminism, the law and development movement, and all the other isms that come with development aid. However, colonialism is the most significant because it left deep and permanent impacts on the way Africans think, the way they relax, the foods they eat, the fashion, their economies. And we cannot view the interaction of state and indigenous laws in isolation of all these changes that are occurring. And this is why I regard state laws as part of the socio-economic changes of colonialism in sub-Saharan Africa. So the radical impact of colonialism in the manner Africans behave demands a different view of perceiving the interaction of legal orders in this part of the world. So this demand informs my argument, which in turn is informed by several years of field observations, interviews, and case studies involving over 400 participants in Somaliland, in South Africa, and in Nigeria. So I question the implicit way the categorization of African laws, the influence of coloniality. I question the way the categorization of African laws fails to reflect the influence of coloniality on the behavior of Africans. And importantly, the potential of this influence to breed or to cause the emergence of common laws in African countries. So I use the concept of adaptive legal pluralism to question the conceptualization of African laws, accusing it of being evidentially flimsy, theoretically confusing, and developmentally unhelpful. And why? Why do I say this? Because adaptive legal pluralism perceives the interaction of legal orders in sub-Saharan Africa as imitative and also as reflective of those persistent patterns of power and philosophy left behind by colonialism. One striking feature of coloniality is how law reforms construct the behavior of Africans into universalist images of the rights to dignity, to equality, and non-discrimination. If I'm to take South Africa as an example, soon after the end of apartheid, since the end of apartheid, law reforms have consistently imputed the values in the South African Bill of Rights. South Africa's constitution is known to be very liberal. So it's been consistently and systematically bringing these values into all aspects of indigenous life, ranging from traditional leadership institutions to succession, to marriage, to land, to every aspect of life. And what normally happens in the courts is that whenever an indigenous law is challenged in the courts for being offensive to human rights principles, the courts strike down that particular custom and legislators follow with law reform to reflect the invalidation. So in sum, the European colonization of Africa should be regarded in a historical sense as a normative marker for the evolution of African laws. So we must draw a distinction between pre-colonial African laws and post-colonial African laws. And because of this demand, I categorize African laws into three. So three types of laws are operating on the continent. The first are state laws. These are European laws and their adaptations that were imposed through colonial legal transplants. In South Africa, we regard them as the Roman Dutch law, the laws of the British and the Dutch, the Netherlands. Then we have the second category as indigenous African laws. These are pre-colonial norms that developed in agricultural settings with the primary aim of group welfare and which are still observed in their ancient formats. A very striking or common example is the mere primogeniture rule, the rule that only the eldest male child will inherit property. So these customs are observed in their ancient formats with little regard to the changes that have occurred in society. And then the last one, the last category is simply African customary law without the label of official or living. And these are hybrid products of colonial contact. So they are adaptations of indigenous norms to the economic, religious, philosophical, and all the other changes brought by globalization, including state laws. The reason why I have categorized African customary laws into these three groups is because of legal history. Legal history shows very clearly that the European laws that were transplanted to Africa will eventually merge with customary laws to produce national common laws. It happened in England. It happened elsewhere in the world. The Romans were the first to colonize the British. Eventually, the Scandinavians, the Norman conquest. So they were there. And all through those long years of evolutions, eventually the English common law emerged as a system of customary law. In other words, the adaptations of English customs to the laws imposed by the Romans and the Normans. So then the question becomes, what is the future of legal pluralism in Africa? This future can be seen through this concept of adaptive legal pluralism, that indigenous African laws are adapting towards the imposed state laws, or the laws that eventually transformed, the colonial laws that transformed into state laws. So indigenous African laws are adapting towards them. And since they are adapting towards them, we need a theoretical framework for legal integration in African states. And I have identified 5 steps for the emergence of this legal integration. In step 1, there will be increased judicial and legislative awareness of Africa's new legal identity, especially the influence of globalization on the behavior of Africans. Step 2, we need to ascertain some foundational values of indigenous laws, because it's these values that inform the way people adapt their norms to socio-economic changes. We need to de-emphasize conflict of laws in the courts and rather emphasize the dialogue that is taking place between state laws and indigenous laws. We need to substitute the Bill of Rights with the foundational values of indigenous laws. So when judges are trying to adjudicate over customs, rather than always imputing the values in the Bill of Rights, they should try and use the foundational values of indigenous laws. In step 4, legislative reforms can then occur to reconcile or to adapt indigenous norms with modern conditions. It's quite unfortunate that in South Africa, the legislators skipped steps 2 and 3 and jumped straight to step 4 by recklessly adopting legislation without really doing the needful. And then finally, customary laws will merge with state laws using the foundational values of indigenous laws. And at that point, who knows, probably 200, 500 years down the line, no matter how long it takes, we'll reach a stage in which state laws will become customary laws and customary laws will become state laws. And so there will be a common law, and not just in South Africa, but also in other African countries. So I thank you.
Thank you very much, Anthony, for your extremely interesting presentation that I'm sure has already opened many thoughts on your proposed categorization. I immediately give the floor to Mary Muscat from University of Malta, who is going to present us on the following topic: monumental trees and British colonial environmentalism in Malta. Mary, you have the floor, please.
Okay, can you see the screen?
It's coming.
Okay, so let's start. By the way, this is a work in progress. So I'm still looking for more sources to beef up this idea that trees were a symbol used by the British as a form of, I'll explain later, of dominance. I'm talking about the early 1900s, round about the 1920s until independence, but mostly concerning the 1930s. As to methodology, there's the main difficulty with doing research is that colonial sources are known for their dearth of detail, okay, especially governors' decisions. Apparently, it was the policy of the Colonial Office, number 11 Downing Street in London. They didn't promote the travaux préparatoires for a number of reasons, but it is something that is acknowledged among historians, such as, for example, police history circles, of which I form part. It is an academic interest of mine, especially colonial policing and the different models that exist. And so basically, my approach is largely anecdotal. I look up diaries, accounts of people who are what is called close to the event, as close as possible, preferably eyewitnesses, newspaper accounts and travelers' accounts, although these can be slightly out of context because they could be visiting the islands for the first time in their lives and totally misinterpret the situation. But what I usually do is look for the triangulation of sources, at least get 3 primary sources that overlap each other, and hopefully that would remove ambiguity as much as possible. And then something which I tend to do is ground all of this within the law. Now, this is more of an exercise in omissions, in looking at the legal lacunae regarding the subject, and I'll explain this as I go along. So the dark side of environmental law is basically another vehicle to permeate prejudice and racism. This is extended through biogeography. So essentially, we're talking here about the inferiority-superiority context. There's a very specific environment within Malta, which is, I mean, typically Mediterranean. And yet this wasn't acknowledged. The first time that this started to happen was in the 1990s with the, and slightly before that, during the 80s, by NGOs, environmental NGOs, who started to address this situation and actually naming it, giving it a name. They were vociferous in this. They said that Maltese environment is not inferior to the British or to anyone else's. So basically, there was a selectivity in the protection of species by the British. The colonial administration only deciding to do that with regards to functionality, value, and beauty, and/or beauty. And you can easily detect this through the language of the law, which was essentially non-legal language and also non-scientific, as I will be illustrating. So to put you in the picture, Malta is an archipelago. There are 3 islands. There's a total surface area of 216 square kilometers, which is like tiny compared to most of your cities. But we have close to 4,500 different species of flora and fauna. Some of them, there's a percentage of them that are endemic, that is belonging only to Malta. You don't find them anywhere else, not even in the Mediterranean. And also some of them are rare. They are on the red list, on the danger of extinction, basically. Now I have compared the density, just to put you in the picture, of the number of species. So in Malta, I have divided 4,500 species over the 316, which gives you 14.02. In the UK, there are 70,000 species over 242 and 400 square kilometers, which gives you a density of 0.3 species per square kilometer. So again, science, as you can see, already demystifies the idea that there is a Maltese environment is not rich, doesn't deserve attention or protection. There was something which I found particularly peculiar in reading texts that described Malta by the British and even in a personal diary that the first governor had, Sir Thomas Maitland, in 1813. He kept a diary because of his voyages. While he was governing Malta, he was also the High Commissioner for the Greek islands. The main one, there were 7. The main one was Corfu, and he had his office there. So he would every 3 months travel by ship to Corfu, take care of the business there, and then come back. So there was this island hopping going on. And there was a lot of comparison between these set of islands as well. One of the issues with most British people was this peculiar idea that Malta only had 3 seasons. Spring, summer, and winter. Basically, autumn is like 14 days long, and then it just switches over to winter. So that was something like mind-boggling to the Brits. It was a known fact that British gentlemen, in particular civil commissioners, could not withstand certain climates. And this was also something which is common also in settings such as the Caribbean. And they would fall in and even die in certain circumstances. They just couldn't handle the heat. Even soldiers, like Governor Maitland was a career soldier, very hardened, still commented about this and hated it. The Brits, even nowadays, still hate Maltese summers. Incidentally, Maitland arrived in the middle of the plague in October 1813, but David will be talking about this in more detail. Maitland was often comment on the similarity, okay, not just, by the way, the biogeography, but also crime and anthropology. And before that, he was governor of Ceylon, so which is Sri Lanka nowadays, and yet he still had, even though Malta was European by comparison, he was Scottish, by the way. He still found a lot of things to criticize, and these are the standard. I called it racism, environmental racism. These are the standard comparisons that the Brits would make between their environment and the Maltese environment. So we had Garrigue, which is not exactly a desert. Actually, it's quite a rich environment, as you can see from the first picture over here. That is the thyme. It's a herb. And again, it was constantly compared to heather, which is in this second photo here. Trees, they couldn't compare to the British trees except those that actually looked like them, which were few, like you can count them on one hand. Felling of trees to make way for the cotton industry. There was a particular time when this was promoted, and the land was turned into arable land and cotton was grown, which was very taxing on Maltese soil, and we don't have much rain even nowadays. It's like 500 milliliters in a year. To give you an idea, 350 is the desert line. Below that, that's desert. So imagine using up all the natural water to fuel this cotton industry. But then the Spanish industry started gearing up, and basically they booted out the Maltese industry. They were had slightly better quality, and also, I mean, their industry was way much larger than the 316 kilometers squared. Again, winter, there was no snow. We never ever could have a white Christmas because there's just no way we could have snow. Hail at best, again, no Christmas trees. Limestone rupestral formations, the cliffs made of limestone, because they are whitish, they were often mislabeled as chalk cliffs, like the chalk cliffs of Dover, sort of. This kind of racism continued until the 70s, the last vestiges of the British, when, by the way, there was independence in 64. I can personally still remember copybooks given out in schools free of charge, and that they had the photos of Princess Elizabeth and her late consort. The Queen was a young naval wife in Malta, by the way. So imagine sitting in class when you're 5 years or 6 years old and getting these copybooks. I mean, that's a symbolism of you can't get more British than that. So what about environmental colonialism? So I picked on these 3. These are the first environmental laws in Malta, 1932, 49, and then we'll look at the historical trees. Basically, these are listed, these were originally listed under the Code of Police Laws. The first two are still grouped under that theme. The third one, historical trees, that was then transferred under the Cultural Heritage Act, Chapter 445. What about these monumental trees? So they were actually called historical trees, but they were basically given a promotion to monumental trees because they were treated as such. There was just one drawback. Because it is a subsidiary piece of legislation, the punishment that you can get is that of a contravention, not of a crime. So it's like 50 euros. Okay. Nowadays, if you chop or damage a protected species, you can get fined up to 85,000 euros. So somehow this has remained within this historical bubble. As you can see, this is dated in 1933 again. So what strikes me here, first of all, it says government notice. Now that speaks a lot, because government notice, it means that the governor actually drafted it. There was no parliament, House of Representatives to vet it, and he just like published it in the government gazette, and that was law. So there was no one who could argue against it or suggest amendments. Okay. Now, if you can have a look at the language, so let's start here. Basically, this is how they have described the trees. It almost sounds like the kind of language that is used in fiction, such as in Gerald Durrell, My Family and Other Animals, which is incidentally is based in Corfu, 1950s. The large pine trees at the back of the palace, the colossal tree, the old Indian coral tree, both in the private gardens, tree huge, whatever that is, in the private gardens, the old olive trees. Now, I used to teach eco-offenses to the BSc in Earth Systems, and I actually gave them this piece of law and told them, would you do some field work for me? Go out, find these trees, take selfies, whatever, you can even hug the tree if you want to, but please show me that you can actually locate them. And they couldn't, because obviously the language is not scientific enough. There isn't even a map. It almost seems like somebody was having an afternoon tea with scones and discussing this peculiar exercise of let's protect these trees, and those are the trees that we know of, and let's describe them in something which is definitely not legal. That's the first anecdote. The second one is the Port de Bombs, the Porta dei Cannoni. It's also known by that name. Now, this is an area, as you can see over here, the green area, it's called Pinetum. That is a large chunk. That was an open space, and the anecdote runs like this. It said that it was used for political meetings. What the British did was they planted it with these pine trees. Obviously, meetings couldn't be held anymore, so they basically used trees to regulate the native population. They went a step further, and they actually enacted this law, Chapter 74, in 1933, as you can see. They actually called it Preservation Act. We are preserving the area. No development was allowed. The reason stated at the time was national security. But the criticism you get from the newspapers is that we know what is behind this. And that is the gate over there. And I took that from Google Maps just to put you in the picture. The trees on the side, that's part of the large area of the Pinetum. Although they are ficus, it's part of the Pinetum. So the dark side, trees as a symbol of colonialism, selecting what is worthy. As I have already mentioned, there was cutting down of olive, carob, and other trees to make way for the cotton fields. We are still doing that, unfortunately, years later. That is an extract from the local newspaper. That's from 2 years ago. 825 trees being uprooted due to ongoing and upcoming projects. The FAA is an NGO, and it says here, Gozo trees at Ittok, which is the main square, are safe for the time being. And this is the open space in front of Parliament in Valletta. This photo here shows police barriers. These were put in place to prevent, there were some impromptu protests by the public against corruption, and the police actually put up barriers like that. Now, this is usually an empty square. It's like one of the passageways going to the center of the capital city. Over here, I put a photo of the Christmas tree, which is usually, which is the only tree, by the way, in the square, and that is made of glass baubles by one of the companies, Medina Glass. So that is lit for Christmas. And during the Green Festival earlier this year, these shrubs and small plants were adorning the open space, and there was a decision that was taken to leave them there permanently. And the same protesters said, we're still going to gather there, and you're not chucking us out of the space. We're still going to use it to protest. So we're revisiting again what the British try to do in terms of political expression. And finally, so what makes a tree a monument? According to whom? According to whose convenience? And what are the trees really representing? Are they being used as a tool? I'm not going to answer that because, again, it's still a work in progress. I would appreciate any feedback on this, because that could help me. It would challenge me a bit, because I don't want to fall into this idea that there's that I am necessarily right. By way of conclusion, I can say that trees have been a main issue again over the past week, because there were more trees that were uprooted, including some of them 70 years old. Okay, so basically they were first planted when these laws were enacted in the 1930s, more or less. It's a topic which I keep looking into, and I think it's still particularly relevant. Thank you.
Thank you very much, Mary. Very interesting presentation. I really enjoyed it very much. Again, this is another presentation that makes a lot of reflections, and I think will determine further discussion later. Now, let me immediately give the floor to my dear friend David Zamitz, also from University of Malta. David is going to present us on the following topic: King Tom's Plague Police, extra legal governance in British Malta. David, you have the floor, please.
Thank you. When I got to know of the title of today's conference, I was thinking of it very much in terms of Giorgio Agamben's theory, where he emphasizes the relationship between rule by law and rule and governance through management. And he basically suggests that sovereignty is not so much the power to enact law according to the rule of law, but it is the power to suspend the application of law in exceptional situations. And I have this quote here from the German law journal. There was an interview with him where he says, now I think to have discovered that both elements, law and the absence of law, and the corresponding forms of governance, governance through law and governance through management, are part of a double structure or a system. I try to understand how the system operates. you see there is a French word that Carl Schmitt often quotes, and that means le roi règne, mais il ne gouverne pas. The king reigns, but he does not govern. That is the termini of the double structure, to reign and to govern. And I try to apply this idea to colonial rule in Malta, and specifically to the genesis of colonial rule. I don't want to go into too much depth here, but there was basically a process by which Malta was occupied by the British for the first 15 years. But the British had agreed to give Malta back to the Knights under the Treaty of Amiens. So they were occupying Malta, but not as a legitimate government, even in their own eyes. Then, in 1815, following the plague, an outbreak of bubonic plague, which took around 2 years, we had the first British governor of Malta, and this was after the Treaty of Paris, which had given the British legitimacy internationally to govern Malta, but not so much legitimacy in the eyes of the Maltese. And I believe that a lot of the history of that period, and particularly the founding of the law and the founding of the mixed jurisdiction, has to be interpreted through a lens which basically makes space for different theories as to the basis of British governance. And there were basically two competing theories. One, which was put forward increasingly by the British, particularly after 1815, was that the British government was basically continuing the government of the Knights. Another theory, which was put forward by the leaders of the Maltese in the struggle against French rule, was basically that the Maltese, that the British government were there to protect the ancient medieval form of government, which the Maltese enjoyed before Malta was handed over to the Knights. So there were these two theories. Each of them accepted British rule, but they founded its legitimacy on a different basis. Because the British increasingly asserted their continuity with the governance of the Knights, they rendered applicable to Malta the Code de Rohan. And this was the last codification of the Knights before they left Malta. And it was very controversial in Maltese eyes, mainly because it permitted torture and it gave the Grand Master the power of being an absolute dictator. It made him the source of all the law. And this was contested very much by the Maltese. So in 1811, well, there was already in 1803 a Declaration of Rights made by the Maltese Congress, where they make very clear that they understood the Maltese to have the power to, if one looks at the second provision, they're saying that the British king has no right to cede Malta to any other power, and that if he chooses to retreat his protection, then the right to elect a new sovereign belongs to us and to the inhabitants of the island without any supervision. And there is a declaration of freedom of religion. And there is also a declaration that free men have the right that no one has any right over the life, property, or freedom of another. Power resides solely in the law. So we can see here that from the standpoint of formal law, this narrative being pushed by the Maltese deputies had to be, however useful it might have been in an initial stage in encouraging the Maltese to transfer their allegiance to the British, it now had to be combated, and it had to be replaced by another narrative. And I believe that fighting the plague provided the perfect opportunity for governance of Malta via a state of exception and for the establishment of British rule as truly sovereign. And I have here a kind of a postcard which shows what was going on in Malta around about 1813, 1840. And you can see that a dead body of a plague victim is being taken out of a house, and there's a woman mourning. Meanwhile, outside, there are these two men who are actually shooting at a cat. Animals were considered to transfer infection from one area to another. And at the bottom left, you had the famous Becca Morti, that is the plague custodians who are basically taking dead bodies out and loading them onto the cart. And ex-votos of the period basically show how militarized the strategy for fighting the plague was. So we can see that here there's a view of Valletta, the outside of Valletta, and you can see that there are military guards guarding huts. And in those huts, there are basically people who are sick with the plague. Now, this one is one of my favorites because it's an ex-voto and it shows the hospital of the Knights of St. John, full of plague victims. There's a man giving his last confession, I think, or to a priest. But if you look at the right, you can see another man dressed in armor of the knights. And you can see how the armor was probably used as a means to try to defend against the plague. Now, why do I say that the plague was an opportunity for biopower? Initially, the British response to the plague was extremely slow and lackluster. However, Maitland, who arrived as the first British governor of Malta after the last civil commissioner had abandoned his office and fled to England, leaving the island without an effective British commissioner for a couple of weeks. When he arrived in Malta, he was a general, and he basically set out to fight the plague in a military manner. So, among other things, he gave orders that all the main villages, you can see here a map of the time, a fence was to be built around them, and the inhabitants were to be subject to a collective lockdown. Sounds familiar, I imagine. And Valletta also was divided into districts, and one person could not flee from one part to another. Now, what's really interesting is that Maitland basically established that if a person tried to escape, he would be shot without any need of any legal procedure. If a person was infected with the plague and failed to report to the authorities, he would also be shot. Now, this coincided with the creation of the Malta police force. The police were established around 15 years or more. Dr. Muscat will remind me, I'm sure, but definitely well before the British police.
Metropolitan.
How many years?
15 years before the Metropolitan Police.
15 years. 15 years before the British police force. Thank you. And the police were spoken of as very fine and dedicated servants of the government, of the colonial government. There is even a case of one policeman who discovered that he was infected with the plague and that he had failed to report it, and who basically shot himself, committed suicide there and then. So you can see a certain zeal in implementing the law. Now, if we look at the text of this proclamation, one of many issued by Governor Maitland, I think we can see here how on the one hand he is establishing himself as a sovereign power on the island, and on the other, how he is doing so through imposing martial law. So he talks about the shameful practice of stealing infected goods out of infected houses. And he says it was His Excellency's expectation that this unfortunate malady would have been completely subdued without the necessity of making any example or of applying to any individual the extreme rigor of quarantine law. But whatever his anxious wish upon this head might be, he cannot be guilty of so great a dereliction of his own duty as either to compromise the health of the other inhabitants of Qasr Kurmi or of the people in the island at large, whose conduct throughout deserves every degree of praise, by refraining any longer from punishing those who either may have the audacity to steal infected goods or the folly to conceive them. And as the law, as it at present stands, has been found totally inadequate to defeat these two sources of propagating the plague, he is pleased to direct and to order, 1. All the part of Qasr Kurmi within the cordon of troops, insofar as relates to the plague, be put out of the king's peace, and be henceforth declared to be under martial law. That a military commission be appointed to carry into effect the said martial law, as far as relates to any case of plague within the said district. That the said commission, so you can see that he is stamping his authority in a very powerful way. He was called King Tom partly for that reason. I want to refer specifically in relation to the police to an article published in 2019 in the Columbia Law Review, where he basically argues that it is not true that the police exist to enforce the law. He says we have this paradigm in our mind that the police the paradigm presupposes that the police's primary role is fighting crime, the zealous pursuit of which leads them to violate civil rights. The history and sociology of American policing, however, suggests that courts and law scholars have misunderstood the municipal police. They are not in the main fighters of crime. They are guarantors of a social order that benefits dominant groups. This article advances an original descriptive account of the municipal police. They are street sovereigns whose powers derives from law but cannot be contained by it. Police have the power to derogate from law as necessity requires, and it is the police themselves who usually have final say as to what constitutes a necessity. Police use of force and plainclothes tactics illustrates this descriptive theory. The theory suggests that law cannot restrain police in the way that American courts and legal commentators typically think it can, but law nevertheless remains important as an enabler of popular and institutional resistance to police abuses. So the argument I'm putting forward here is that the police in Malta, their genealogy does not derive from an attempt to enforce the law, but it derives from an extra-legal power in a state of exception where they were willing, so to speak, employees of a sovereign. They were street sovereigns in Malta too. Now, in the last part of my presentation, I try to bring this up to date, on the one hand, in relation to the COVID pandemic, where once again, we are having these measures. For example, and when it comes to burials, it seems that the ordinance of Maitland has been reapplied by the Maltese authorities. So anyone who dies with COVID is sealed in a tomb and kept there for 10 years without the possibility of exhumation. Now, this apparently doesn't make much sense medically, but nevertheless, we can see this reaction. But I see this more clearly in relation to migrants, and where we can see even before the COVID pandemic in the last 3 years, there were a series of police actions by which they cleared groups of informal African migrants from their accommodation in Malta. And very often the legality of their action was very tenuous, and it was explained afterwards. So, for example, there were the tenants of a particular stables in Marsa who were cleared from the stable on the police on the grounds that their accommodation was not dignified. It did not respect human dignity. But of course, rendering these people homeless and leaving them to sleep in the streets might appear to be even more of an attack on human dignity. A few other examples. We have the Halfar China House migrants forced onto the streets. What happened is that the landlord apparently was not being paid sufficiently for the migrants, for a particular group of migrants. And he told them, although he was receiving rent, he asked the police to evict them. He had been accepting rent of €100 a month from each migrant, with several sharing each room. So he was already earning quite a lot of money. The private landlord's actions appeared to be very well coordinated with those of the state. He seems to have asked the police to evict the migrants when they were no longer, how shall I put it, profitable enough. And the police seem to have accepted his word without any need to consult any other law. Very interesting is this particular building was divided into an upper part rented to Indian laborers as part of a deal with a recruitment agency, and the lower part rented to sub-Saharan African migrants. The upper part seems not to have been disturbed by the police raid. And it does not seem to have been all that dirty. So the upper part seems to have been okay, but the landlord wanted to keep those tenants. He got the police in to evict the lower part of the building. A few other examples, always the same thing. There's an attempt now to evict migrants from the open centers, put them on the streets. This was just before COVID. But also a hotel in Bujibba. Apparently there were reports of a rat infestation. So the police came and evicted 80 migrants from this hotel. There were emotional and angry scenes as some tenants refused to go and others produced documents claiming they were living in Malta legally. I have been to UK, France, Spain, Germany, all from Italy, and I haven't ever been arrested at 5 in the morning for just renting a room. Officers found people living in cramped condition. Why and how did the police intervene? Officers cordoned off the area. There were reports of a rat infestation. During the raid, one police officer was bitten by a tick and taken to be treated by the medical team on site. So apparently they found a flea or a mosquito to justify that it was unsanitary. We have here the main legal basis, which seems to have been that they declared a public health emergency, apparently after the intervention. And they said the reason why we moved in, so the legality was sought afterward. Anyway, I know the time is running out. I think I'll just move on to my conclusion, which is basically that if we look at the recent Fela Zoo case, where Malta was found responsible for having imprisoned a particular migrant who did not have COVID in a small room with other migrants who were infected with COVID, and to have exposed him to inhuman and degrading treatment, partly as a result of this by the European Court of Human Rights, we can see that in a sense, there is this concept of internal colonialism and this recreation of this paradigm of governance, which doesn't pay that much attention to the law, but coexists with it in a strange binary manner, as Agamben says. And I believe that this is the dark side of the law, in the sense that it is something connected to the law. Apparently, you can think of it as being part of the same system. Nevertheless, it operates according to a different logic, which has to do with sovereignty, discipline, biopower, biowarfare actually, and therefore is not really part of the rule of law at all. Thank you.
Thank you so much, David. Another very interesting presentation, and let me thank the speakers for having been perfectly stick on time. I think that we have a lot of food for thought, and I immediately give the floor to the participants who can raise their hands or indicate their willing to make a question or a comment into the chat. Who wants to break the ice? Who wants to break the ice? I mean, I'll take if no one.
Can I ask something?
Sure.
It is for Anthony. I really like the ideas that you're putting forward, but I was wondering how we can achieve this if our courts are only schooled in common law in South Africa, for example. So the only procedure they know are those described in terms of legislation that were or comes from England and the Netherlands. So it would mean that we have to overrule the courts and the procedures that they follow, because the rules of evidence that they know are only those that are found in typical Western legislation.
Indeed, yes. Thank you for the question. It's one of the biggest challenges we have regarding the interaction of indigenous laws with state laws. We've got judges that are trained only in the Western legal tradition. So until we bring forth a new generation of law students who will eventually step in and become judges, then it means that we'll continue to grapple with this situation in which state laws suck in indigenous laws to the point of extinction. It's an unfortunate situation, one we cannot do anything about at the moment. We can only speak of what we know. So those judges in there, they are products of a system that knows no other way of doing things.
If I'm allowed to follow up, you're probably well aware of the commissioner courts that existed in South Africa till I think in the 80s. And they were schooled in customary law and they applied customary law in those courts. And they were disbanded at that stage because it was said, and especially by Africans, that those courts do not treat them or the litigants the same as people are treated in the Western court. So it was at the insistence of the African population or some African scholars that those courts were abolished and no longer exist.
Yeah, so I don't know, should you want me to respond to why the courts were abolished or the impact of the abolition?
No, not at all. I was just wondering whether it would be possible to bring back those courts if it was already tried before and it did not succeed.
Yeah, I don't think it will be possible to bring back those courts because who will man them? Who will be in the courts? So who will administer those? It's people who possess specialist knowledge of indigenous laws are those who are needed in these courts. And if we don't have them, we cannot manufacture them. So quite unfortunate, we can't.
Thank you.
Who wants to be the next? Andreas, please. You have the floor.
Thank you. Thank you very much for 3 really interesting presentations. I learned a lot, which is very nice for a conference anyway. Before I actually had meetings of the exam board, and this is what we have now, is absolutely the opposite. I found all 3 things absolutely fascinating. I didn't know that trees actually and planting trees is a means of oppression. It's actually something which I actually had to learn, because environmental things are meant to be good ones, and apparently it depends what you do with them. I found that very interesting. I found it also fascinating, David's talk, also in relation to the question of the role of the police. It reminded me of I have to say, it's a bit more a comment than a real question, but or perhaps it can be seen as a question. David, do you see probably a kind of, when you refer to this Columbia Law Review article, a kind of similarity to the statement by David Graeber, the sort of anarchistic anthropologist, who actually said that the purpose of the police is not actually to prevent crimes, but to document them. I found myself reminded of this kind of thing. I mean, the interesting thing is it is definitely a means of exercising power, and not necessarily preventing crime, because crimes can actually be quite useful to enable or to maintain power. So, I mean, I found that also absolutely fascinating. Do you see a similarity in this kind of thought? Or
I think, yeah, I mean, of course, I mean, even Durkheim had already said, you know, that in a sense, crime is functional to social solidarity. So it's not really a very new idea. But of course, documenting can itself be a means to exercise power through writing things down, categorizing them, classifying them. And of course, you know, power knowledge, not to be too Foucauldian, but as we all know. I think in the Maltese case, I would go further, that specifically in relation to certain kinds of irregular migrants, there is a kind of a tacit complicity almost with the police, by the police, in actually creating conditions in which particular groups really end up being in a very irregular situation where anything they do is going to be a crime. So, you know, the example I gave of migrants being evicted, you know, and rendered homeless is just one. But another would be, and here not maybe just the police, but the whole state in a way, in pushing migrants towards irregularity and away from stable legal status. And that's something which it seems to me is happening in many parts of Europe, of course, not just in Malta. In Italy, there were the Salvini, the Decreto Salvini, I believe. In the UK at the moment, Priti Patel seems to be far more about, how shall I put it, rendering migrants' lives fragile and precarious rather than about stabilizing them. So, unfortunately, yes, I think police are part of the means through which a state of exception and emergency is created. And once that shift is made possible, then you no longer have to consult the lawyers before every step you take.
Mm-hmm. It's very interesting, and also the fact that writing down things is actually an exercise of power, which is sort of going to Anthony's sort of issue of how to create customary laws by actually writing them down in restatements and things like that. Although I don't want to take more time for other questions, so.
I think you can make the question if you want.
I can't make the question. Then to Anthony. Now, I found one thing is also a comment found absolutely fascinating was that he simply said, well, you know, what happened in Africa is not actually something specifically African colonial. Look at the common law in England, you know, which of course I said as well, but it is still so that, you know, you, even as a sort of well-meaning anthropologist, you look at Africa as a thing on its own from a European perspective, and this is actually quite rubbish. There's this sort of quite interesting idea of the reception of the Roman law in certain parts of Central Europe, which is also a form of colonialism, but only, of course, in certain parts. You have got aspects, even in the German civil code, that actually the law of the hypothek is actually divided between the old German customary law, which has still survived in North Germany, and the Southern German Roman law influenced civil law, and you have got this rupture formally still in the German civil code, although it's practically no longer relevant, but I think it's still in force. So you have got these mixtures and things as well in Europe, but interestingly, it's always looked at from, you know, we come to Africa and look at it in sort of colonial way, and you simply say, well, we have got all sorts of ways of dealing with that in Africa, which is totally commensurate with which we happen in Europe. And this is actually exactly a very good approach to see that we will have sort of a kind of reception, not necessarily a restatement, which of course, especially in the colonial times, had to fulfill a purpose of power. Especially in the indirect rule, but simply really a kind of mix which becomes a common law in the sense of a mix of customary law, also not anything new. A lot of commercial law is lex mercatoria, customary law, throughout the whole Middle Ages. And I mean, for example, the law of bills of exchange is that, you know, so there is, and then it was statutarized then, you know, but it was actually sort of old customary laws, which actually worked across Europe, otherwise you couldn't trade. And I think this idea to have something like that in Africa, I found it a fascinating approach. So, I mean, I don't really have an exact question, except perhaps, do you think that legal academics can play a substantive role in that? It's a quite civilian approach, because professors are much stronger in their opinions of lawmaking or influence of lawmaking than the so-called common law systems.
All right, thank you. Yeah, so yeah, that question is a very fascinating one, but it's also a challenging question in that for legal professionals to lead or champion this integration, this emergence of a common law, they have to be aware to an extent of the nature of indigenous laws. They have to be somehow familiar with empirical research, and only then can they bring up a new generation of policymakers who can influence change. Right now, the approach seems to be top-down. It's not bottom-up. So the state simply comes with, oh yeah, we're going to make this legislation, and then let's consult. The traditional leaders will protest as usual. Eventually the protest will be overridden and the legislation will pass. That's what we're seeing.
Thank you. And thank you for the fascinating talks. I've learned a lot. All three. It was really brilliant. Thank you.
Thank you. Who wants to be the next? Any more? I mean, the chair should not ask questions in principle, but if you allow me, considering that we don't have any other hands raised for the time being, I actually have been really interested by all the three talks, and I would like to make very short, briefly, a question to the three speakers. Anthony, I really enjoyed your presentation, and I really appreciate your effort to make a step forward from the methodological approach to the study of law in Africa. My question, I mean, I would have a lot of questions, as you can imagine, for your presentation, but I will refrain from doing all these questions. Maybe we can do this. We can have a deeper discussion separately. But one of the things I would like to ask you is this one: when you presented your recategorization of African laws, basically you presented the three types of laws in Africa. The first one is called state laws. The second is indigenous African laws. And the third one is African customary law. Don't you think that at least for the second and the third one, terminologically speaking, there could be a confusion in those who are not really familiar? I mean, as you know, we have discussed this many times when I was in Cape Town. I don't like the denomination of customary law. It's the one accepted, but I hate it. But don't you think that categorizing indigenous customary could create confusions in those who are studying customary laws in Africa? To Mary, it's very interesting what you said, and I immediately made a trade union, I would say, from your presentation again to what happened in Africa. It seems to me, but I would like that you that are more expert in this field, your presentation falls within the general idea of the use of agriculture as an instrument for colonization. I mean, in Africa, we know from the colonial times that in introducing a cultivation in a specific area of land meant that that area of land had to be used by colonizers and not anymore by local people. I see your presentation in the same direction, but I would like that maybe you can say something more on this. David, very interesting from your presentation from the anthropological point of view, and more fascinating for me that I started this year to teach legal anthropology in Palermo. I have been interested a lot both in the role of the police and in the area of migrants. The question is, the presentation you made about this article from the Colombian Law Review, also what Andreas was referring, it's a sign that, in your view, that the role of the police is changing in a sense that we see, for example, in US, the role of the police changes and police plays its role differently. For example, if the target person is a white or a black, the way how they exercise the crime prevention slash as you say, description is different if according to the targeted people. It would be nice to have your views on this.
Okay, so who goes first?
Anthony, I think you're the first.
Okay, so yes, so thank you for that question. The issue of nomenclature, name, is something that is common. It's a common problem in academia. There will always be differences and variances and disagreements over names. If we call it traditional law, one will have problems with it. If we call it native law and custom, there will be problems. Customary law, same thing. Indigenous law, same thing. But the distinction between indigenous African laws and African customary law is an important one. because it helps us to understand the process of transformation, how agrarian customs transform and adapt to meet modern realities. Let's take just a very brief example of male primogeniture rule. So in the past, that rule emerged in an agricultural setting in which family wealth was produced together, and a strong figure, authority figure, was needed to lead the family, mediate between the spiritual world and the physical world. That's the origin. Now, if that custom is applied in the same way it was applied in the past to our modern situations, let's say the eldest male child is living far away from their ancestral home, he's no longer able to come home and take care of the family home as they used to do in the past, it becomes problematic. So now, supposing a family says, no, we're not going to leave all the family wealth in the hands of the first son, trusting that he will administer it for the benefit of the entire family. And they said, let's split it equally amongst all the male children. That is a change in indigenous law. Now, supposing another family says, let's do better than that. We are enlightened. Let's divide it amongst all the children, irrespective of whether they are male children or female children. That is a change in indigenous law. So you see the process of transformation. We need that distinction to demarcate laws that are applied in their ancient pre-colonial forms and laws that have been adapted to suit modern conditions. So that's why I keep that distinction.
My turn.
Thank you so much, Anthony. We will continue the discussion in Cape Town. Next time I come.
So,
Mary.
shall I, Mela, from what I found, the issue with agriculture was a very delicate balance, especially after the cotton disaster. The British realized that they wouldn't meddle so much with agriculture because if something went wrong, it meant famine in the country. The main industry was agriculture, and then the port area. Imports, I mean, as David has shown, Malta depended on ships, okay, for imports of food. And that was already very sometimes non-sustainable, because if whatever was imported was infected, or there was a rat on the ship that was infected, that would just decimate 1/3 of the population very easily in a matter of weeks. And this is the same with agriculture. So the British learned earlier on that you don't meddle with such a small size. What they did was they actually left their mark on Maltese cuisine, because basically they like eradicated it. My father was in the British Navy. He was actually a chef, and at home we just ate anything British, and we weren't the only family who did that, because like fish and chips, when we are a Mediterranean country that is based on supposedly olive oil and anything which is not fried the same way as the British do. Okay, what I can tell you, instead of agriculture, they had this practice of creating enclaves, geographic enclaves, where only the British could go. There was one particular sandy beach, and I want to acknowledge David on this one because he reminded me of it, that was cordoned off, and only the British officers could go with their families to swim. And it was thanks to that rule that and it's a secret that the lecturers at the biology department of our university know, and it's they're like they don't really talk about it, but when they do, they're like over the moon, because it preserved the Maltese ecosystem, okay, from trampling, from the population trampling over the area. And it's the only beach that has fossilized sand dunes. So the sand dunes were actually so well preserved that they became fossilized in the biological term, not in the like millions of years fossils type. And certain flora and fauna species were protected that way. So in a sense, maybe the blunders of the British also lent a hand to preserving Maltese flora and fauna. not necessarily through agriculture, because it was too delicate for them to mess up with it, especially after the cotton blunder, definitely. I hope I have answered your question.
Okay, so I guess it's my turn now, right? In terms of this whole issue of race and how it plays into policing, right? I was actually starting off from another article I found, which talks about Agamben's two missing factors: understanding state of emergency through colonialism and racial doctrine. This was published in 2020 in the Journal of Open Political Science. And the whole idea being that this theory of the state of exception has been linked a lot to the Western political institutions, from the Greeks and Romans, the Homo sacer, moving on to the present. But actually, this is to ignore the whole colonial dimension, where very often whole countries were kept in a state of exception or in a state of emergency for decades. So I think the interplay between the colonial and the metropolis has to be kept in mind. So I take completely what Anthony was saying, which, if I understood rightly, at a certain point, he was saying that certain structures of governance were already being practiced within the common law, within the European environment, before they were applied in the colonies, right? And I'm basically saying that as regards the police, the Maltese police force, was an ancestor of the British police force. So they practiced something in the colonies, which they then imported into the metropolis. So I think there's always this constant shifting. At one point in time, certain things are possible in the colonies, which are not possible in the metropolis, but eventually they get imported, so to speak, and applied there. So yes, I do think, and then when it comes to policing, what was very much in the back of my mind is also the anthropologist Tal al-Assad, who tries to argue for a genealogical approach to concepts like inhuman and degrading treatment. He says, you cannot discuss it without keeping in mind the whole agenda of civilizing the natives and not tolerating their barbaric practices. So eliminating sati in India was part of the prehistory of concepts of inhuman and degrading treatment today. And I believe the concepts still bear the trace of their origin. So when we try to apply them on the institutions, we have to deal with all the accumulated meanings and practices, which have very often a strong colonial history behind them. And that's why it's very easy then to end up reproducing these situations of domination and exploitation and so on. And then, of course, it can work the other way around. So you can have practices by which the British working class, for example, were subordinated, which are eventually exported to the colonies. So one area which I find really interesting, I've been trying to study clock towers in Malta. We have around 8 colonial era clock towers. And it's very clear that these were used also as a way of instilling British time, British temporality, and getting the natives to be very, very efficient in their work. So subjecting them to a regime of temporal governance. This came particularly to the fore in India, but it's obvious that it was also applied a lot in Great Britain itself. So there is this constant interplay.
Thank you very much, David. Any further question? it seems not. So I would like to thank the three speakers and the participants for this extremely stimulating session. I enjoyed it very much. I think it was really great. We can therefore stop it, and reiterating this vote of thanks, I invite you to continue to stay with us for the next sessions and for the final plenary that will close our conference. So thanks again, and see you later.
Thank you.
Thank you.
Bye.
Thank you.
Bye.
Thank you, everyone. Thank you.